Hi, I'm Anna Denton-Jones of Refreshing Law Limited, and in today's session I'm going to be talking about anonymous witnesses in disciplinary cases. This might be an external witness who's perhaps written in anonymously about something, but it could equally be somebody internal who is prepared to tell you about something, but only if you promise that their identity will remain anonymous, perhaps because they're concerned about reprisals or being seen as a snitch or something like that. The starting point for the employer is always going to be the British Home Stores and Birchall test when we are dismissing anybody potentially for misconduct. So that test requires us to think about whether we've got a reasonable belief that somebody is guilty of something, and we reach that by having reasonable grounds to believe that based on all the evidence that we've got in front of us at the time. And we get to that place by virtue of the third ingredient, which is conducting a reasonable investigation in all the circumstances. So where you've got anonymous evidence, you're probably going to have to go even further than you would normally to test that evidence and, for example, try and corroborate it with other evidence than you might in other cases. So, for example, there was a case where an informant had told the employer anonymously that they thought somebody who was off with a back injury was not actually as sick as they were making out, and that triggered the employer then being able to use video evidence to corroborate what that person has said. So you do need to think about corroboration. You're going to need to think about, if it is your own employee who's raised something anonymously, to what extent we can actually interview them and ask them questions and really test why they're getting involved in this. So is there a motive? I've had lots of cases where line manager has disciplined somebody and then there's the motive for revenge later on by the disgruntled person who didn't believe they should have been told off for something. So think about if there's any kind of motive behind the way in which the person is acting, and whether their request for anonymity is reasonable in the circumstances. The Linford case is a touchstone where the Employment Appeal Tribunal set out that if you are going to redact, for example, black out the name of a witness before you give those statements to the employee who's been accused of something, and of course they would still get that evidence, we can't hide it from them if it's going to form part of the decision-making process, that you would need to behave in certain ways. They recommended that, if possible, the decision maker, the person who's going to deal with the disciplinary hearing, perhaps also interviews the person who's given anonymous evidence so that they can make up their own minds about the weight to put on that evidence. Obviously, the person who's accused is still going to see the evidence. The decision maker may have to adjourn the disciplinary hearing in order to go away and ask that person further questions before they can make up their mind. The employee who's accused might make quite reasonable representations during the hearing about the evidence that's been given by that person, and the decision maker might have to say, okay, I'm going to have to leave the hearing here now, I'm going to go away and I'm going to ask witness X the following questions, and then I'm going to come back to you and I'm going to tell you what that person has said, and then I'm going to get more representations from you, and then I'm going to make my decision, if that makes sense. They suggest also in the case that you make careful notes of everything that you've done and how you've done it, because of course that may become relevant later on. It is important, if you are allowing witnesses anonymity, to explain to them that there is the possibility later on that the Employment Tribunal might order that anonymity has to be lifted. There have been cases where that has happened. You might have to go further than you thought you might when you black out details from witness statements. So, for example, there was a case against Walker's Crisps where there was a scam going on in the factory to steal £20 notes that had been put in bags of crisps for the public to win. And the witness statements would have identified who the maker of the statement was just from their description of where they were stood on the factory line and what they could see from where they were. That would also identify the maker of the statement just as much as their name or anything else. So you might need to go a little bit further in respect of those sorts of details. There is no right to anonymity by the employee. It is for you to obviously make a decision about. So, you know, an employee can't, for example, resign because you've disclosed that they've made a statement to another employee. There might be circumstances where you doing that would be a breach of trust and confidence, but generally they don't have a right to anonymity. If you've got any questions, please do not hesitate to email me, adenton@refreshinglawltd.co.uk. Thank you very much.